back to winning isn't easy. Let's talk about how unrealistic settlement expectations, because of a lack of understanding or willingness to believe what the policy or plan had to say, can doom an ERISA mediation. And I call this the if my wife doesn't get 100% of the full value of her claim, I'm going to divorce her argument. Okay. Now, many ERISA disability policies have provisions in them that people don't necessarily appreciate, but ultimately they need to come to understand, because the court is going to be looking at these provisions in deciding whether the denial or termination of benefits is correct. And just because you don't like them doesn't mean they're not applicable. So what I find is that when many ERISA disability claims are denied or benefits are terminated, ultimately you may have to file a lawsuit in federal court to challenge this determination. Under the federal rules of procedure, we have to attend a mediation conference to resolve the legal issues in dispute if we can. And because of the uncertainty of litigation and difficulty in overcoming a standard of review, which is a golden handcuff on judges, many cases will settle. Now, carriers do not pay 100% of a claim. Never, ever have I ever seen in my many years of practice that any carrier, be it a disability carrier, a personal a personal injury claim where the car insurance or the carrier, or even in a workers' comp case, nobody pays 100% of the value of a claim. Carriers and plans will evaluate their exposure based on the value of the benefits in dispute, the policy terms, and sometimes even who the judge is. And as a result, in ERISA cases, policy type or plan cases will often settle for anywhere from 25 to 50% of the value of the claim. Is that fair? Heck no. But that is the reality. So let's talk about the impact of policy limitations on the value of a claim. Disability policies often contain limitations that impact how long benefits are going to be paid and for what conditions. Some policies or plans will have a mental nervous policy limitation, providing that a disability caused by psychological issues is limited to just 2 years of benefits. And there also might be another version of that, and that's what I call the Monty Python mental nervous policy limitation, which says, hey, if your disability is caused or contributed to ever so slightly, benefits are limited to just 2 years. Now, there are also subjective medical condition policy limitations or plan limitations. And what they'll say is that musculoskeletal disorders and certain subjective medical conditions like fibromyalgia or migraines can be limited to just 2 years. Now, these clauses, these subjective medical condition clauses, come in different flavors too, which is why it's important that you're reading the policy or the plan so you understand what benefits you might be eligible for, how you go about developing the necessary medical proof, and trying to insulate yourself against the application of the mental nervous policy limitation provisions or the subjective medical condition limitations. So let me give you an example. Let's assume that the policyholder or the plan beneficiary suffers from migraines, and the policy limits the payment of benefits to just 2 years based on the subjective nature of the condition. And without this limitation, the policyholder might be eligible for benefits until age 67. But once this limitation is in place, benefits are capped at 2 years. So get out a pad and a pencil, or get out your phone here and just take notes, because we're going to do some math. Let's say the monthly benefit is $5,000. Over 24 months, the total benefits would be $120,000. Now, if the policy does not have the limitation, potentially based on the facts of this case, the total benefit could reach $600,000 by the age of 67. But under the terms of this policy or plan, benefits are capped at $120,000. There's no more. In a recent mediation, the policyholder's husband told the mediator and counsel that he would not allow his wife to settle for anything less than $600,000. He even went so far as to say that he would divorce her if she accepted anything less, because he felt it wasn't fair to him, because he had been paying all the bills, for her to settle for less than the perceived value of the case. Did that case settle? Now, the carrier offered 100% of the value of the 24 months of benefits, the $120,000. The settlement offer was rejected. And ultimately, if this case proceeded, I am sure that a judge would rule against them. And certainly the case would be zero, not $120,000. Having unrealistic expectations, even after clear explanations from counsel and the mediator, meant that this case did not settle. And one can only presume that they're still married, but they certainly will have lost their ERISA policy, their ERISA claim due to these policy limitations. These are things that are very important that you need to understand from the very beginning of your claim, the development of the medical evidence, and the strategy that can potentially be employed to limit, potentially, the application of these types of policy terms or plan terms that will limit the period of benefits for certain medical conditions. Got it? Let's take a break.